got an idea I plan to submit a provisional application for. I will work with a patent attorney, good for you. It's for a clothing design. A quick search finds nothing similar in patents or applications or in commercial production. However, the space I'm in is growing. So I'm worried there are unpublished applications out there, right? Recently filed applications. My question is there a way to search for provisional apps before they're published? There's one way. If I move forward with a provisional application and also start to prototype, are they published? If I move forward with a provisional and also start to prototype, produce items, if someone did in fact file a similar design prior to me, will I get into a battle? Okay, great question. I love it. This is not well known, but when a patent application, either a provisional or a utility non-provisional, is filed, it is not published right away. It is not automatically. Only after 18 months after filing your original priority date is it published, around 18 months. So a year and a half of time exists where prior art, right, previously filed patent applications are unfindable to the public. So I mentioned that one way to find it, and that's to be a USPTO patent examiner. I know, funny. All right, but it's true that they will look, rarely, they will look only if there are two almost identical patents that are submitted. They will go take a peek at a provisional application to see if it fully enables that eventual non-provisional, and if the subject matter aligns, and they will award the application that's pending to the earlier file. It is a first to file system. Even if the other can prove they invented it first, right? So long as they're both independently derived, that's a key word. Maybe one didn't learn from the other, which is another interesting avenue of discussion. Then it will be whoever filed it first. So that's when they go look, and this battle they're talking about, a priority battle, could ensue.
Is that, JD, that's a great answer. Is that an interference hearing at the USPTO?
It's no longer called that. The American Invents Act changed that. So an interference used to be where it was a who invented it first. And that all went away because there's a bunch of back and forth, people coming out of woodworks with their signed certified notebooks and their professors' documents saying, oh no, it was invented now. That doesn't matter. The impetus is not who filed it first. There could be a battle at the PTAB if someone argues, oh no, that earlier filer derived it from me. Maybe if you, under NDA or whether a public disclosure, they defrauded the patent office and said they were the inventor when really they weren't.
So it's a race to the patent office, which is different than on the trademark side, which is still first in time, first and right.
Yep, that's a big difference. And I think the policy reason is there. We don't want inventors sitting on their ideas. We want to make the world smarter as soon as possible. That's the whole point of make the U.S., I guess, right? Most educated, and to get that information out as soon as possible. It's one of the big exchanges at the patent office. You share information with the government, they reward you with that limited federal monopoly. Now,
JD, like this potential client, whoever, if they file a provisional patent application, do they receive an application number, and are they able to legitimately say patent pending if they're provisional?
Yes. Even for a provisional application, as soon as the application is filed and you get an electronic receipt that was received, immediately patent pending. So it's the same status as if you filed a full formal non-provisional with all the claims and bells and whistles.
Cool.
Just patent pending. So yeah,
right.
Thank you for that.
And the patent pending gives notice for damages. Is that kind of the idea?
You nailed it. So if you've got that on your product and you can sell it, you're providing actual notice to a third party. If they decide to be a bad gal or bad guy and rip you off after being put on actual notice, they're potentially liable for treble damages, triple big time damages. And it's a heavy, threat to settle or to try for federal court damages. So, yep,